So you have Rule 5, Part 4, and then you have all these Roman numerals 1, 2, 3, 4, 5, 6, 7, 8. 8, and then 4.5, and then 5, and then B, C, and then 1, 2, 3. Okay, so I only did half of this. I'm doing the other half right now. Within 7 days after the defendant is brought before the county court for or following the filing of the felony complaint in that court, either the prosecutor or the defendant may request a preliminary hearing. Upon such request, the court forthwith shall set the hearing. The hearing shall be held within 35 days of the day of setting, unless good cause for continuing the hearing beyond that time is shown to the court. The clerk of the court shall prepare and give notice of the hearing or any continuance thereof to all parties and their counsel. Number 2, the preliminary hearing shall be held before a judge of the county court in which the felony complaint has been filed. The defendant shall not be called upon to plead. The defendant may cross-examine the prosecutor's witnesses and may introduce evidence. The prosecutor shall have the burden of establishing probable cause. The judge presiding at the preliminary hearing may temper the rules of evidence in the exercise of sound judicial discretion. Number 3, if the county court determines such probable cause exists, or if the case is not otherwise resolved pursuant to a dispositional hearing, if no preliminary hearing was held, it shall order the defendant bound over to the appropriate court of record for trial. In appropriate cases, the defendant may be admitted to or continued on bail by the county court, but bond shall be made returnable in the trial court, and at a day and time certain all county court records except the reporter's transcript notes or recording shall be transferred forthwith by the clerk of the county court to the clerk of the appropriate court of record. 4, Roman numeral 4. If from the evidence it appears to the county court that there is not probable cause to believe that any or all of the offenses charged are committed by the defendant, the county court shall dismiss those counts from the complaint, and if all counts are dismissed, discharge the defendant. Upon the finding of no probable cause, the prosecution may appeal pursuant to Rule 5A 4V, file direct information pursuant to Rule 5A 4VI, charging the same offenses, or submit the matter to a grand jury, but may not file a subsequent felony complaint charging the same offenses. V, if the prosecutor believes the court erred in its finding of no probable cause, the prosecutor may appeal the ruling to the district court. The appeal of such final order shall be conducted pursuant to the procedures for interlocutory appeals in Rule 37.1 of these rules. 37.1, the interlocutory appeals. Such error, if any, shall not constitute good cause for refiling. 6, Roman numeral 6, VI. Upon the finding of no probable cause as to any one or more of the offenses charged in a felony complaint, the prosecution may file direct information in the district court pursuant to Rule 7C2, charging the same offenses. If the prosecutor states an intention to proceed in this manner, the bond executed by the defendant shall be continued and returnable in the district court at a day and time certain. If a bond has not been continued, the defendant shall be summoned into court without the necessity of making a new bond. 7, VII. If a felony complaint is dismissed prior to a preliminary hearing being held when one is required, or in other cases prior to being bound over, the prosecution may thereafter file direct information in the district court pursuant to Rule 7C4, charging the same offenses, file a felony complaint in the county court charging the same offenses, or submit the matter to a grand jury, or submit the matter to a grand jury, or submit the matter to a grand jury. If the prosecution files a subsequent felony complaint charging the defendant with the same offenses, the felony complaint shall be accompanied by a written statement from the prosecutor providing good cause for dismissing and refiling. For dismissing and refiling the charges within 21 days of defendant's first appearance following the filing of the new felony complaint, the defendant may request an evidentiary hearing at which the prosecutor shall establish the existence of such good cause. VIII 8, Roman numeral 8. If the county court has bound over the defendant to the district court and the case is thereafter dismissed in the district court before jeopardy has attached, the prosecution may file direct information in the district court pursuant to Rule 7C of 5 charging the same offenses, file a felony complaint in county court charging the same offenses, or submit the matter to a grand jury, and the case shall then proceed as if the previous case had never been filed. The prosecution shall also file with the felony complaint or the direct information a statement showing good cause for dismissing and then refiling the case within 21 days of defendant's first appearance following the filing of the new felony complaint or the direct filing of the new information. The defendant may request an evidentiary hearing at which the prosecutor shall establish the existence of such good cause. 4.5. A dispositional hearing is an opportunity for the parties to report to the court on the status of discussions towards disposition, including presenting any resolution pursuant to CRS 16-7-302. 16-7302. The court shall set the dispositional hearing at a time that will afford the parties an opportunity for case evaluation and potential resolution. Number 5. Are we having fun? Are we having fun yet? Procedure upon failure to request preliminary hearing. If the defendant or prosecutor fails to request a preliminary hearing within 7 days after the defendant has come before the court, the county court shall forthwith order the defendant bound over to the appropriate court of record for trial. In no case shall the defendant be bound over for trial in another court until the preliminary hearing has been held. The 7-day period for requesting a preliminary hearing has expired, or the parties have waived their rights to a preliminary hearing. In appropriate cases, the defendant may be admitted to or continued upon bail by the county court, but bond shall be made returnable in the trial court at a day and time certain. All court records in the case, except the reporter's transcript, notes, or recording, shall be transferred forthwith by the clerk to the appropriate court of record. 5B. Bail in absence of a county judge. If no county judge is immediately available to set bond in the case of a person in custody for the commission of a bailable felony, any available district judge may set bond, or any such person may be admitted to bail pursuant to Rule 46. Rule 46. What is Rule 46? I bet it's a bunch of bullshit. Rule 45 is time. Bail. In consideration the question of bail, the court shall be governed by the statutes and the Constitution of the state of Colorado. So listen to the constitutions of Colorado and the U.S. That's Rule 46. When it comes to bail, you got to listen to the constitutions, okay? When it comes to bail. Now, when it comes to Vale, Vicky Vale, any available district judge may set bond, or such person may be admitted to bail pursuant to Rule 46. Misdemeanor and petty offense proceedings. Procedure following arrest. If a peace officer or any other person makes an arrest, either with or without a warrant, the arrested person shall be taken without unnecessary delay before the nearest available county court. Thereafter, a complaint or summons and complaint shall be filed, if it has not already been filed, immediately in the proper court, and a copy thereof given to the defendant after or before arraignment. Trial may be held forthwith if the court calendar permits. Immediate trial appears proper and the parties do not request a continuance for good cause. Otherwise, the case shall be set for trial as soon as possible. Number 2, Appearance before the court. At the first appearance in the county court, the defendant shall be advised in accordance with the provisions set in subparagraphs A2I through VII and IX of this rule. And IX of this rule. Appearance in the county court not issuing the warrant. If the defendant is taken before a county court which did not issue the arrest warrant, the court shall inform the defendant of the matters set out in subsection A2I through VII and IX of this rule. IX of this rule, and allowing time for travel, set bail returnable not less than 14 days thereafter before the court which issued the arrest warrant, and shall transmit forthwith the transcript of the proceedings and all papers in the case to the court which issued the arrest warrant. In the event the defendant does not make bail within 48 hours, the sheriff of the county in which the arrest warrant was issued shall return the defendant to the court which issued the warrant. CRCP 5. And that's all she wrote. I don't know where XI is, or IX 9. It says 8. And then it says IX of this rule. Well, of course, according to Rule 9 of this rule, there is no fucking Rule 9, you dickheads. You fucking pricks. It's 8V, III, and then 4.5, and then 5, and then B, C, 1, 2, 3. No IX. So when it says A2I through VII, and IX through 9, we're assume that there's, and we're going to skip over 8. I don't understand. Oh, IX. Wait a second. In the very beginning with 2, the right to a jury trial if serving in the U.S. Oh, that's all the shit that they're supposed to tell us in the beginning, right? Yes, 2. Okay. After these messages, we'll be right back.